person came to engage you to do something for him. You went to buy some products in preparation for the contract. He's now saying there's no more interested in the contract again. There's a receipt. So specifically, you can claim that amount as your special damages because it's something that you can prove it with receipts. In normal court business, as Doc will confirm, the courts are very wild. Let me put it that way. When it comes to the issue of special damages, the court wants you to prove it with precision. So that's general and then specific damages. Also have in mind that if you're going to claim damages, the damages should not be remote. If the damages are very remote, the court will deny you. So what you are supposed to get should have some kind of link, and that link should not be far away from what a reasonable man would have anticipated under the contract. So you also look at the remoteness of damages. It's something that you should be looking at. Then, if you also go further, look at two other things that I want you to in the revision period. You look at penalties and liquidated damages. There are instances where parties may agree that in the event that one person wants to opt out of the contract by breaching, that person is supposed to pay an amount of money because of his breach. It's been liquidated, it's been quantified. So the moment you want to move out of the contract, you know that you're going to pay X amount of money to that person. So that's the liquidated type. Then you also have what we call penalties. You know, your reading will tell you that the courts are not willing to endorse penalties. So no matter how you look at the clause in the contract, whether it's termed liquidated damages or penalties, a party may want the court to look at it to see whether it's indeed liquidated damages or penalties. As you know, penalties, they are clause inserted in contracts simply because that the party do not want the other party to breach the contract. And they set in such a way that it is normally above what is reasonably expected in case of a breach. So if the clause is a penalty, there are rules. If the clause is liquidated demand, there are rules. So look at liquidated damages and then penalties. Then I also want you to quickly look at laws that you incur in terms of damages. Now, if there's a breach of contract on the part of the other party, you must make sure that you mitigate your losses. If you fail to mitigate your losses and you just want to wait and extract everything from the other party, you may be in for a very bad business. So as a party who is going to court to get damages, you must demonstrate that when the incident occurred, you mitigated the damages. Classic example, someone has told you that he's buying X product from you. That product is perishable. You wait. The person tells you that he's no more buying the product. You have about a week for the product to perish. Are you going to wait for the product to perish and then come and claim everything from the other party? No. You must find means of disposing of that product, maybe at a reduced cost. So a difference between what you had as against what you were supposed to have under the contract, you can claim it as damages. So you must make sure that you mitigate your losses. It's so critical that as students going into these exams, you may meet some of these instances where a party may not want to mitigate his losses or his damages, and he wants to go to court and get everything. You must, at every stage in the contract, when there's a breach, mitigate your damages. Now, let me take you straight to another remedy of specific performance. You see, there are instances where parties may want to intentionally breach the contract, no matter the situation. But the other party also knows that he needs that kind of product that he has contracted that party to supply. So instead of saying that you're going to claim damages for the breach, you may say, no, you're not going to breach it, but you are not going to countenance the breach of the other party. So you want the court to specifically order that person to respect his side of the contract. So that's the remedy of specific performance. It's an equitable remedy, as you all know. So in equity, you know, if you're going for these equitable remedies, you must have all the canons in place. For instance, You know, you can't go to equity with dirty hands. You must act timeously, delay the fees equity, all those things come into play. But when it comes to matters like land, individuals enter into a contract for the sale of land. The person may come to you and demand maybe $10,000. You are prepared to pay the person $10,000. You sealed everything. The person moves out of the room. Someone offers him $12,000. Then he tells you, I'm not going to respect the contract. I'm not going to sell the land to you. In that circumstance, you reserve the right to go to court and ask for specific performance, because the land that you are looking for may be at a prime area that even if the person were to give you another land, that will not be suitable for the purpose for which you enter into that contract. So usually, instances where it will be very difficult to get the subject matter of the contract, you can go to court and pray to the court to specifically order the other party to perform his side of the contract. So please look at specific performance as one of the remedies. Now, let me take you to the next one. I'm rushing through because I say this one is a salad one, a potpourri, so I'm just have to rush you through all various areas. Now, you go to injunctions. Now, injunctions, as you all know, is also an equitable remedy. And before you can be granted that remedy, you must prove certain elements. The person like will tell you, you must prove a prima facie case. You must act timeously. Then it must be damages will not suffice in the circumstance if the injunction application was not granted. So all these ingredients will have to be proved before a court may grant you an order of injunction. Now, injunction may have various forms. You may have interlocutory injunction or interim injunction. When you say an interim injunction, it simply means an order that has been made by or decreed by a court of law for a limited period of time, maybe 1 month, maybe 2 weeks, maybe 2 months. So when the time expires, you may want to go to the court again for another order to be decreed in your favor. So that is in the interim. But practitioners most at times may want to fuse interim with interlocutory. No, interlocutory injunction is a form of injunction that's decreed by a court or granted by a court up to the final determination of the cause or matter. So here it's not about 1 week, it's not about 2 weeks. So far as decision or judgment in that matter has not been delivered, that injunction order subsists. So look at interim, then you also look at interlocutory. Then injunctions also can be applied for, as well as you say, either on notice or ex parte. Ex parte simply means you go to court without notifying another person for an order to be decreed in your favor. But note, the ex parte order does not last more than 10 days. But when you talk about injunction orders made on notice, it means that after you have filed the application, another party was served, then you went to court to put across your case, and the court came out with a conclusion. So injunction can be interlocutory, it can be interim, it can be made on notice, it can be made ex parte. Then the same injunction, you can also be talking about perpetual injunction as well, because some people may say, what about perpetual injunction? It's also a form of injunction that's given by a court after the determination of the issue before the court. So note, perpetual injunctions are decreed only after the determination of the matter in contention. But before the matter is determined, you can apply for either interim or interlocutory. But when the court delivers its judgment and the court wants to restrain that person from doing that act again, then perpetual injunction may be decreed. I've taken you through this. We did something that I think Doc will sometime in normal classroom. We have to take some time to go through that. But this is what I want you to know under remedies. I started with damages. Then we came to specific performance. Then injunctions. I know the other remedies, you know that you may want to rectification, rescission, all those things are there. But look at these three. It doesn't mean that you need to chew anything, but understand the concept. So the moment something comes up from any of these areas, you can easily come out and then address it head on. Now, having finished the first menu on the salad, which this one may be maybe the fruit, this one may be pineapple or something. Let's move to the next one, which may be apple. Let's go to thought. The law of thought. Now, thought is an interesting area that students usually, those of us who attend Legon, Professor Kumado, will just make it so interesting for you to understand. And I thought you may want to look at various areas, but for the purpose of this evening's delivery, I may want us to look at assault, battery, then perhaps some few areas. Because most of the times, people get confused when it comes to the difference between assault and battery. In practice, you may see the two having been fused or meshed. But any law student will tell you assault is different from battery. And the difference between assault and battery is that one of them is direct, the other one is not that direct. So I usually tell people that assault is battery minus something. So you have battery minus something will give you assault. So what's assault? Assault is what we call incomplete battery. It's an incomplete battery and it is actionable per se. The apprehension that you bring on the mind of another person that you are even about to touch that person will constitute assault. So you need not prove any damages. It's actionable per se. So here, there's no direct touch, there's no direct contact, but by your actions, that other person had in mind that you were about to do something to him, either by touching the body or do something sinister. So that's assault. You have the classic case of insia versus ampretum. It's a case that I think you're already aware of. But there are some basic elements that you need to have at your fingertips when it comes to assault. The first that the assault must be the direct act of the plaintiff. There must be a direct act. The person did something directly, wanted to perhaps touch your body. He never got touched your body. So now there's an apprehension within you. So there's a direct aspect. That directness must always be proved. Then the direct act or the act you are talking about must be voluntary. If the action was not, or the act was not done by the person on the person's own volition, assault may not lie. If, for example, someone pushes me towards you aggressively, it wasn't my intention to head towards you aggressively like that. Someone must have pushed me, meaning the action is not direct, it's not voluntary. So that kind of voluntarism must always be proof. And the classic case is Gibbons versus Pepper. You know that case. Now the third element is about the state of mind of the defendant, the person seeking to touch you. In criminal law, we're talking about mens rea. Here, I'm not talking about mens rea, but this is still about the state of mind. Did the person have in mind that he intended to touch you or to get closer to you in an unwarranted manner? So the state of mind is something that you may have to prove if you may want to succeed when it comes to assault. Then the next one is that before you can also succeed under assault, you must prove lack of consent. Lack of consent. Because if you fail to prove that you never consented to the act, you are likely to go home without any remedy. So the want or the lack of consent on your part will certify the court that indeed the person wanted to assault you. And you know the cases under the lack of consent. Now, the act we are talking about must be a positive act, but not an omission. So the person seeking to assault you must do a positive act. So it's an act of commission, but not omission. A positive act. So that is it for assault. Now let me take you straight to battery. Battery is also actionable per se, without proof of damages. It's actionable per se. that's a brother of assault, but here there is an actual touch. There is an unpermitted physical contact on your body, unpermitted physical contact. So here, the ingredients are just like assault, but I'll just run you through them. The only difference has to be the actual touch. The first one is that there must be a direct act, as I explained under assault. The act must be done voluntarily. So in that case, the person must act on his own volition. Then there must be a physical contact. Physical contact. When we're discussing assault, I never mentioned physical contact, but here there must be a physical contact. And for that matter, if you're a plaintiff in such a case, you must prove that there was a physical contact. The contact need not be complete. The slightest of it amounts to assault. So there must be a physical contact. In the same way, the state of mind is very critical. What is the state of mind of that person who touched you? It's something that you also need to prove when it comes to battery. Now, there must be a positive act, just like assault. That one is something that you also need to have in mind. So, in terms of assault and battery, know the difference. If you see assault, you must know that is assault. If you see battery, you must know that this is battery. So that's it for you under assault and battery. Perhaps let me just add negligence for you. Negligence, I'm not going to go deep, but please have in mind the three main areas under negligence. And have in mind the standard of proof required. Have in mind Donoghue and Stevenson, when he talks about someone is your neighbor, please have that one in mind. Because if you get into negligence, you need to have those things at your fingertips. Perhaps Doc, I know Doc is well versed when it comes to healthcare law. Medical negligence is part of negligence. So please, recently something happened at 37 or something, where someone went in for, I think, from some treatment, and then we had this kind of thing. One of them sued. So please, look at negligence, and then let's see how that one too. When it comes to medical negligence, definitely, you know, the standard of care is what we call the Bolam test or the Bolito test, depending on who the test that you want to have. So, Doc, I hope I'm clear. Please, are you hearing me?
Yes.
All right. Yeah, I wanted
yes.
to have the feedback. Clear. All right. Thanks so much. Now,
yes, I can hear you. Yes.
You can hear me. All right.
Quite clear.
All right.
Thank you.
Thanks so much. So, those of you who were not hearing me well, I just ended on negligence.
Okay. Thank you.
And I said, negligence, you should have the three key ingredients of negligence. But because recently we have medical negligence, since you are going to write law exams, I may want you to advert your mind to what has been happening at 37 or one of those hospitals where someone went in, he sued and gotten some damages. So please look at that aspect of negligence. Then let me take you to the third leg of my delivery. And the third leg, I want us to look at constitutional law. Under constitutional law, I know that you are familiar with Article 75 of the Constitution. Please, if you are not familiar with it, this night, go back and read your Constitution. Because it's an area that every day you hear arguments on. It's about the government having the power, or the president having the power to enter into international agreements or treaty with other bodies, and the requirement that such international agreements must meet parliamentary ratification or approval. There are a series of cases on this, and I think as students preparing to write the entrance exams, you must have Article 75 at your fingertips. Recently, or was it last year, there was this Equitable 2 case Gitmo 2, where some people were brought in, and then there was a case at the Supreme Court as to whether those people who came in, the manner that they were brought in amounted to an international agreement. And in that case, I don't have a citation, but it's reported in 2017, 2020 Supreme Court of Ghana law report. The Supreme Court held that even note verbal or diplomatic notes constitute international agreement. You may not have a written agreement to the extent that we even think that oral agreements are also agreement. So now it's not about having something that you say is on paper, A, B, C, D, or E, but anything that seeks to bind Ghana and another party will be construed as an international agreement. So the Gitmo 2 matter has settled it. It needs not be written in black and white in this big, but it can be a series of documents exchanged between government of Ghana and other states. So that one is something that you need to look at, Article 75. Now, I also want you to look at Article 181. And 181, especially the clause 5. Now, those of you who are familiar with Article 181.5, yeah, I think someone has given a citation for the Gitmo 2 cases, Banfo versus the Attorney General. Thank you very much. Now, the Article 181, if you read Article 181.5, there is this modification that in the event that there's any other agreement, commercial agreement, the government also have to bring the same thing to Parliament for approval. But if you read Article 181.5, Parliament has been given the authority to give us the ambit of Article 181.5 as to which agreements must come, which business transactions must not come. But to date, Parliament has not given us that kind of compass for us to navigate through. So it has taken the courts to make pronouncements. So that area is still very, very fluid. It's an area that if you are dealing with, you may not be certain, especially now that there is this argument of people having major contractual agreements and minor contractual agreements. The Balkan case, as some of you may be aware of, there was this argument that even the government of Ghana decides to buy air tickets for its officials to London, British Airways tickets, those transactions could be construed as international agreement because British Airways is owned by foreigners. Or government wants to even book hotels for its officials who are going to New York. That hotel company now has an agreement with Ghana. Does it need parliamentary approval or ratification? But the Balkan case has now given us some kind of way that some of the agreements are not major, but they are minor. For them, if they are minor agreements, they need not go through Parliament for parliamentary approval. So that's how come in the Balkan case, there was this issue about buying of tickets need not go there, but other aspect, the major aspect of the contract, will have to go there. But as I say, it's still not very clear. It's an area that still we need to look at. My suggestion, if you are questioning on that, is for Parliament to be alive to its responsibility by going through the process to itemize international commercial agreements that should come before them and those that should not come before them. Now, on the same Article 181, now the current issue has to do with, I think I'm a politician, and you know, the Sputnik V. And as to whether what the Ministry of Health did needed parliamentary approval, there's no doubt that provided, or so far as the agreement was between the people of Ghana and then an international person, someone outside the shores of Ghana, it was an international commercial agreement. It needed parliamentary approval. But the question I've been asking, and which if I were your examiner, I will ask, if the Sputnik drugs had been imported or purchased by Food and Drugs Commission or the Food and Drugs Authority, as you all know, will such an agreement also have to go to Parliament for their approval? Is a question I'm posing. I'm repeating the question. if the vaccines had been ordered by, for example, Food and Drugs Commission or Food and Drugs Authority, will such an agreement, or should such an agreement go to Parliament for parliamentary approval? I've seen that someone has answered no. Why no? Someone is saying yes. Why yes? Doc, is it permissible so that at least I'll let them just maybe join and then perhaps give me a perspective of why they think yes or no? Please, can someone, those of you saying yes, can anyone? Yes, someone is saying that yes, because it involves government of Ghana and others. All right. Now, those of you saying yes, you are saying that so far as that entity, FDC or FDA, is an entity of the state, you think that that agreement ought to go to Parliament. That's the view of those of you saying yes. Those of you saying no, it is your opinion that that entity is not the government of Ghana, and for that matter, it should not go to Parliament. But this matter has been decided by the Supreme Court. In the case of Clomega versus Ghana Port and Harbor Authority. Ghana Port and Harbor Authority. Now, the ratio in that case is that agencies of government that are legal persons or which have legal personalities, they have their own boards, even though they are under ministries or agencies. So far as they have that kind of autonomy, they reserve the right to enter into international agreements, but such agreements need not go to Parliament for their approval. So note it. Food and Drug Commission, if, that's I'm giving the assumption, if it is an autonomous entity, in quotes, with a legal personality, which can sue and be sued, then in that case, if it enters into contract with that man in Dubai for the supply of Sputnik, that agreement should not go to Parliament on the authority of Clomega versus Ghana Port and Harbor Authority. And that decision is that one. Let me get you the citation. The citation 2013-2014. 1 SCGLR 581. 2013-2014. 1 SCGLR 581. So you may be examined. If I were the examiner, I would put a problem question. Yes, and someone has also posted in the GMPC case, you're also right. That ratio was also repeated. Dr. Makasibe and ECG, I'm happy that you have all the authority. So please know the distinction and make sure that when you are confronted with any issue surrounding that, you can easily do justice to the problem. And I think if you read the Gapoha case, Justice Dateba said if such an entity was operationally autonomous of or autonomous agency of the government, meaning the government has an oversight, however, that entity is autonomous. So please make sure you look at that. As I said, if I were to examine you, I will take you through that one and see how you understand the basic concept when it comes to that one. Now, let me take you after Article 181, 75, and then the 1815. I want you to take a look at Article 268. Article 268 of our Constitution. I don't know whether you are familiar with it, but I want to read it to you. It's another article that I think as students study constitutional law, you also need to know. I'm reading, if you don't have constitution there. Article 268(1). Is it any transaction, contract, or undertaking involving the grant of a right or concession by or on behalf of any person, including the government of Ghana, to any other person or body of persons howsoever described, for the exploitation of any mineral, water, or other natural resource of Ghana, made or entered into the coming into force of this constitution, shall be subject to ratification by Parliament. So the Eston Cubic case comes to mind. If you read this article, those of you who watch my vetting, I raised that issue. A careful reading of it shows that even if you are an MP and you have some funding to dig some boreholes in your constituency, so far as you've entered into agreement with someone to harness the water resource of Ghana by digging the borehole for you, that agreement will have to go to Parliament for ratification or agreement or approval. So you see how that one is also a bit fluid. It's an article that you need to look at when it comes to mineral resources. People come in for the lease and having attained the lease, it's okay. All those things will have to go to Parliament. So far as you are having in mind Article 181, I also have to have in mind Article 268. That, and the key words here, you have to look at exploitation of any mineral. You know what is meant by mineral, or water, or other natural resources. Someone has posed a question, what about private boreholes? An interesting question. Private boreholes. If I want to sink a borehole in my house, and I enter into a contract with a company to come and sink it for me, please read it, whether that one is applicable. It's an area that I think students will need to look at that. In the same way, if you take the same Article 268 by Article 268(2), Parliament has been given the leeway to make some exemptions. I doubt if Parliament has done so. Because, for example, the private question that is the question just someone sent to me. If I'm digging a borehole in my house, what do I have to take to Parliament? If I'm an MP, I want to dig from 10 boreholes for my constituency. Why should I do it? If my village needs water, I need 5 boreholes. What should I go under? So they must come out with these exemptions. So this is something that you may have to critique when it comes to the performance of Parliament and our present dispensation. There are some areas that they are supposed to act, if not acted. It has taken the courts to go into those areas to come out with some decisions. I think it's time that Parliament was made to perform some of these constitutional duties that have been entrusted to them by our Constitution. So that's it for you under Article 75, 181, and 268. Now, let me take you quickly to an area of interest. You might have met it already because we've had other lectures who have also had discussions with you. Article 11, Clause 7 of our Constitution. It's an article that I see as also one of the areas that we need to look at. Article 11, Clause 7. If you don't have the Constitution, I'm just reading part of it. It says, any order, rules, or regulations made by a person or authority under a power conferred by this Constitution or any other law shall A, be laid before Parliament. So that's the first process. If someone wants to make rules of court, they are orders, regulations, LIs, CIs. Now the whole thing is that the first thing is that they must be laid before Parliament. CI must be laid before Parliament. That is true. CI for the rules of, when it comes to rules of court, must be laid before Parliament. You take the rules, the Court of Appeal rules, or the CIs, but that's the process. They must be laid before Parliament. They must be published in the Gazette. Then they must come into force 21 days after 21 days sittings of Parliament. Now, someone has posted one of the cases that I just did at Supreme Court. Judgment was delivered about a month ago. Association of Finance House versus the Attorney General. The argument in that case was that Bank of Ghana had revoked some licenses or had made some rules pursuant to which some of this entity had their license revoked. They went to court arguing that so far as Bank of Ghana made rules, those rules qualified under Article 11.7. And for that matter, Bank of Ghana needed to lay something before Parliament for Parliament to approve before they could carry out such a duty. But the Supreme Court disagreed with them and said, no, those things were purely administrative matters that the Bank of Ghana was carrying out. So for that case, someone has posted it, I think something that you can get and then read. But under the same article 11.7, there is something that I want you to be thinking about. If you look at the 11C, maybe the EC has brought a CI to Parliament. Per Article 11.7, Parliament has no power to amend. Even if they see that there's a comma somewhere, and that because of that comma needed not to be there. Per Article 11.7, Parliament has no power to even amend anything, even if it's a grammatical mistake. What's provided is that Parliament will have the power to just reject it outright or endorse it. And do you think it's fair? Do you think it's reasonable that when Parliament realizes that there's even a mistake somewhere, something that they need to just correct, they say so far as they've laid it for 21 days, if they do not reject by 2/3 majority, it means that that thing has become law. Please, let's look at that. I think that process where they have to redraw the whole thing again and start afresh must be looked at. But I think the Supreme Court has pronounced on it. And that's the current state of our law. Parliament has no power to amend a CI that's laid before it. Article 11.7, Parliament has made a rubber stamp. It's either they reject by 2/3 majority or they endorse without touching it. Please, is it fair? Is it reasonable? As students of law, please be thinking about that. Now, let me go to the last bit of my salad for you this evening. Then perhaps due to other commitments, we may want to call it quit. It's almost 1 hour. I intend to spend about 1 hour. Now, you are also aware of the Rastafarians case, the students, Achimota students. Please, that case, if you have not read it, go and read it. You need to read it and see, make your views out of it. I know that is an appeal pending against it, but you should well versed with the issues in that case. Pick your constitution, marry it against the decision, and see whether the decision is reasonable. The Tyrone Magai case. I have my own opinion about it. I've shared it openly. That if you take our constitution, the barometer in measuring our rights is Article 12, Clause 2. That's a standard barometer. 12.2 is telling us that you can enjoy every right, but it is subject to the rights of others as well as public interest. So that's the first. So if you're going to maybe discuss anything about rights, Article 12.2 must be in your mind. Because whatever thing that you say about rights, you must have in mind that Article 12.2 is there to check you or checkmate you. That's the omnibus barometer. But if you come to specific clauses or articles, there are some checks. One of them is Article 14.1e. And 14.1e is about the education of a child. And that the child will have every right. But even when it comes to education or welfare of the child, that child's right will have to be shared in favor of his education. So question, a child wants to go to school with a dreadlock. Then there's a policy by the government that, no, you cannot go to school with that dreadlock. Will you say that the government has breached or, yes, have flouted the right of that individual? No. Because if you look at Article 14.1e, the state has been given the power to determine what a child should enjoy when it comes to education. There's that aspect of paternalism. The state now has taken over parental role of parents when it comes to children. So when the state says these are our rules, you cannot enter into any institution without having your head trimmed down. Finito, that ends it. Because by 14(1)(e), when it comes to education and welfare of the child, what the state says is, so question, the parents of the Rastafarian students who were denying their children to go to school, who were denying their children from because they thought that fine, if they're not going to admit, they're not going to allow you to go to school, the Rasta here, we're not going to allow you to go to school. Can you say that they were rather breaching the rights of the child? I'll say yes. Because if you take the Children's Act, if you're a parent and you deny your child education based on your religious belief, you can be taken on. Because every child, as you know in Ghana, has no religious belief. I say it confidently because every religion of the child has been imposed on the child by the parents. So before the child gets to 18 years, then someone has posed a question. Now, what about if the child was 18 years? 18 years. Interesting. Because here it talks about a child who has not attained the age of 18. So in that case, Article 14(1)(e) will not be applicable. It means that the child can go to court and fight for his rights. If the child is under 18 years, then the child will have to be. There's a question about Wesley girls and issues about they not being allowed to fast. Yes, a child may have has a religious that kind of right to fast because if you're a Christian, sometimes Christians also fast. Muslims fast. I think that issue was overflowed. It's an issue that if you were to subject to legal scrutiny in court, I can assure you that those children there, until and unless there is a state intervention that stops children from fasting, they cannot be stopped from fasting. They cannot be stopped. But also, they cannot be compelled to fast. So that one is different from the Rastafarian one. So please have that one in mind. I think someone has posed a question on Article 33. Let me see. Yes, has posed a question on Article 33(1). He said, what about that? I'm reading so we all look at it. He said, where a person alleges that a provision of this constitution on the fundamental rights and freedoms has been or is being or is likely to be contravened in relations to him, then without prejudice to any other action that's lawfully available, that person may apply to the High Court for redress. So here, it simply means if you don't have to sit down for your rights to be abused before you can go to court. If you feel that your rights are likely to futuristic, you can go to court. That's the first one. Or your rights have actually been abused, the actual situation, you can go to court. And the court that you can go is nowhere but where? The High Court. So note that when it comes to human rights issues, if you want to go to the court, you cannot go to any other court but the High Court. Of course, you can go to the Supreme Court for a declaratory relief and a declaratory relief as well as interpretation. Lawyers do it. You may want to go for interpretation that will amount to a declaration of that right or enforcement of that right. It's allowed. But if you're going to the High Court, please make sure you look at that. Someone, I think, asked a question about discrimination. Article 17. Yes. No one should be discriminated against. But if you are a child in school under 18 years, when it comes to your education, the state has the power to discriminate against you by not letting you enjoy certain rights. So that's a simple answer. You can discriminate against, but it must be within the confines of our constitution. And so these are the areas that I have on my plate. If you may want to have some questions, we'll look at it. I have seen this question from Jacob, LGBT. LGBTQQ plus, 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 plus. Now, I know there is contentious issue as to whether they have the right to practice anything of their choice when it comes to sex. Now, sex is personal. But you know, when it comes to practice of sex, it's regulated by statutes in Ghana. And that's the reason why you cannot go and sleep with someone who's below the age of 16. You cannot go and force someone to have sex with. And if you take our Criminal Offences Act, so I'm taking you to a criminal law, about section 1043, thereabout, the state has criminalized unnatural carnal knowledge. And what's unnatural carnal knowledge? Having sex, not through, from what my perspective, the vagina. Because if you talk about knowledge, it's like about penetration. Penetration is about the penis and the vagina. Now, any other area that you may want to enter amounts to an unnatural carnal knowledge. So, if you are a man and you want to have sex with another man through his anus, by our law, you've committed a criminal offense. The only problem is that people do it in their bedrooms. They do it in their bedrooms. So where is the evidence? So the law is there. So the moment you do it and then you are caught, the law will have to deal with you. Ghana is a state party to a lot of international conventions and treaties. If you take the African Charter on Human and People's Rights, if you read the preamble, it talks about the culture of the people. It also talks about the family as the basic unit of the African culture. So, if you want to say that you want to practice same-sex and marriage in Ghana, even taking away the section 104, if you can prove that there is a culture in Ghana that allows the practice of it, then perhaps we can be putting across a case. Have in mind that customary laws are part of our laws. We take Article 11. No, yes, customary laws, they are part of our laws. And for that matter, if there is no custom that permits the practice of same sex, whether between male and female, some male and male or female and female, you dare not go there. Now, the argument has been made that if you do so, you may be trampling upon their rights. It amounts to discrimination. They've been created that way, so they are hormones. That argument is fundamentally flawed. It's flawed in a sense that there are some people who were born thieves and armed robbers. You can provide everything for that person as your parent. You go to school and steal. When such a person steals, is he left off the hook? He's arrested and prosecuted. So in that case, you cannot say that because people are born with it, they must be allowed openly to practice it. Kleptomaniac, as someone just put it there. So if someone comes and tells me too, I was born with such, I have this inclination that I must be drinking blood. That is how God has created me. I must drink human blood. So if you criminalize that kind of lifestyle in me, as someone has posed, you are discriminating against me. No. If my lifestyle is to drink blood, Ghana, human blood is not permissible. Are you a vampire? So far as no culture, no law allow such a thing to practice here, my take is that those things are not permissible either under our international obligation under the African Charter on Human and People's Rights or per our domestic legislation. That's my take on LGBT, IIZ, or YYY, whatever. Please, any other question? And someone post something, but I forgot someone post me to, let me see. Yes, let me look at this. There's a question here. Is it how honorable, how can we say that legislating against LGBT and providing for the entire nation to hold that opinion contravenes Article 56 of the Constitution? Can the provision be construed to that effect? All right, it's something that you also, Article 56. 56 basically, just a minute. The Parliament shall have no power to enact a law to establish or authorize the establishment of a body or movement with the right or power to impose on the people of Ghana a common program or set of a religious or political nature. Fine. I think that argument can also be made. But in any case, nobody can impose something on us. If someone wants LGBTQYZ, whatever, to be practiced, the person must convince us that our cultural laws, our family system allow it. Save that, I would say, our laws must rather be enhanced so that people who tend to propagate, who tend to promote that aspect of life will be held in check. Now, there's a sharp question on Article 71. Article 71 is an interesting provision. I think those of you who have followed me for some time, for about 5 years, I've spoken about it publicly on various platforms. But look at it well and see the processes. And I'll pose a question to you for you to ponder over. Does the president, I don't mean the sitting president or any other president, have the right to change any recommendations made by the committee set up pursuant to Article 71? Look at that one. If the president has the power to change any of those things there, then perhaps the argument can be made about the recent happenings in Parliament and as to whether or that one is sub judice. But on the face of it, Article 71 is limited to a group of people. In construing provisions of the Constitution, you cannot add. It's a specific provision on some group of people. So any attempt to bring in someone outside that bracket will definitely be unconstitutional. So please, Article 71, let's look at that. And then someone about the New Lands Act. That act, I've shared my opinion on that act too. There is this interesting provision in that act, the Act 1036. There's a provision, I don't have mine here, but there's a provision that has now allowed what we call the John Doe principle. I don't know whether you've heard about the John Doe principle. Now, the John Doe principle is the effect that if someone is developing on a piece of land and you cannot get that person to sue and serve, you can simply go to court and sue the trespasser. Prior to this Act 1036, lawyers were doing it, suing trespassers. At that time, there was no law backing the John Doe practice in Ghana as we have in the UK. But the New Lands Act has brought up that provision to the effect that you can sue a trespasser and get a remedy. It's one of the positive sides of it. Then if you also look at the same act, you have provisions on chiefs and how they deal with outskirt lands. Can a chief, for example, say that you're a farmer on a piece of land? The land is now outskirt. We want to demarcate with the plot, so we are not going to give you anything. Now there's a formula that this act is seeking to put across so that people will know the number of plots that they are to have from outskirt land and how they are to go by that. There's a contentious one, which I think my sisters and the ladies on the platform, I think guys have been talking about that. That's in relation to spousal rights having been smuggled into the New Lands Act. But that provision there is not absolute. There are exceptions. So please read that provision well. It is not automatic that when the wife acquires it, my wife acquires it, automatically I'm a member or I'm part of it. If you read that section under the Lands Act, there is a proviso and that you can go around it. Then in terms of the work of the lawyer, the New Lands Act has given lawyers some money into their pocket. Because now, if there is any instrument affecting land, and that instrument has not been signed by a solicitor, that instrument will be rendered null and void. So I think it's something that we also need to look at. All right, let me just take you off here, and perhaps if you have other questions, general areas that we want us to be looking at, but for purpose of your exams on Tuesday, please look at current topical issues. Current topical issues and your opinions about those issues. Now, under criminal law, I want you to take particular attention or pay particular attention to Section 179, the law on causing financial loss to the state. Read that section well and make your views or opinions known with regard to that section. Because now it's quite topical. Look at it and see whether that law is a law that we should continue to have. But in looking at Section 179, I also entreat you to look at what we call a Government Contracts Act. Government Contracts Act. AFRCD 58. AFRCD 58. If we are to prosecute corruption, if we are to protect the public purse, apart from Section 179, the other provision that we need to look at is the AFRCD 58. That piece of legislation has criminalized conduct when it comes to negligent conduct on the part of public officials when they are dealing with government contracts. If you are a consultant to a road project, the contractor is giving the work. You are the one supposed to monitor that work. You are the one supposed to raise certificates. If you raise a certificate for a contractor to be paid without checking, either deliberately or negligently, and as a result of that, the state lose any money, please, you'll be held accountable under the AFRCD 58. It's a good legislation that I think you need to look at. You know, defenses under criminal law, look at your defenses. When it's murder, look at the defenses. These are the areas that I think I have on my plate for now. If someone has really a question about the St. Monica girls' case, that one, please discuss it at your own level and then look at whatever you are supposed to do. But the question that someone has posed about the outskirt land, if you talk about outskirt land, is a kind of a piece of land that lies outside a town or city. But with time, the development of the town has caught up with that land. And because it has caught up with it, you cannot continue to use that land for other farming or other purpose apart from building. So it now becomes the duty of the stool or skin to make sure that it demarcates the land into building plots. But the person who is in possession cannot be denied portion of that land by the New Lands Act. Before this act came into being, there was an earlier decision endorsing it. But this act has made it clear. The percentages are now set out. Now, someone is asking about committee of inquiry and commission of inquiry. Obviously, you know the import and the effect. Commission equivalent to a high court. There should be a white paper. Committee can be set up by a committee, by the commission, by the executive. So please look at that one. There's someone asking a question about the African Charter International Bill of Rights. Now, if you ask me, I will tell you that the African Charter on Human and People's Rights is more specific to our cause than the International Bill of Rights. In any event, the International Bill of Rights, if you are talking about the Universal Declaration on Human Rights, that one you all know is not binding. It's rotatory. If you come to the ICCPR, fine, or ICESR, those of you who know who the international human rights. So in terms of my discussion on LGBTQ, whatever, I have to limit myself to the AC, the African Charter on Human and People's Rights, because we are in Africa. Our culture is African, and everything has to be African. So my view is that LGBTQYZ, whatever, is unlawful, and its practice in Ghana should not be countenanced by the state. I want to end here and tell you that I'll be praying for you as you approach the exams. Take your time. Don't be in a rush. If you are writing, write legibly. Please, if you are writing, write well. If you are writing, write so, because if a lecturer or a marker is going to mark about 50 scripts, one of the things that examiners will look at something about the handwriting. If it's not good, make sure that the lecturer can read. If you make your handwriting horrible, maybe the marking may also be horrible. So enjoy the rest of the evening. You'll be in my prayers. I wish you all the best. So Doc, this is where I'm drawing the curtains. Is Doc still with us? Please, is Dr. Dapa still with us? All right, his line dropped. All right. Then thanks so much. We will meet definitely one day somewhere. Maybe some of you may even be in my office in the near future. Then we see how things go. God bless you. Thank you very much.